Hey, well, hello everybody. Welcome back to another episode of Coffee with Michael. I have Renee Noy with Workwise Law back with us today, and we're just talking about how blind we're both going. So it's okay. So Renee has been on here a number of times. I'm not going to go deep into her background, but I do think it's important to get a little bit of information out there for anybody who's new watching these. So Renee is a partner. She's one of the founders of Workwise Law. I've met Renee, God, a lot of years ago. I can't even remember how long, and just a wealth of information. She great expertise as well because she started on the plaintiff side, and she spent, I think, close to 10 years there, and then she migrated over to the defense side. So now she's defending companies. But it's really fun for me when I get to ask her questions and poke around a few things. She's able to talk about not just from the defense side, but hey, look, as a plaintiff attorney, this is how they think. So it's very good information to have. And I going back through her resume, it came up again. She earned her BA from the University of Colorado, and she was summa cum laude, which means she's a heck of a lot smarter than I am. It's always a pleasure to have you on. So Renee, hi, good morning, welcome.
Thank you. That's a very sweet introduction. Thank you, Michael.
You're welcome. Anything you want to add to what you're doing before we get started, or just
Did I just go black?
no? Is there anything you wanted to add
No,
to your
sorry,
background?
my monitor just went completely black on me.
Oh,
Don't want to add anything. No. No, I mean that's an accurate statement. I was on the plaintiff side for 13 years. And so now it's been over 8 years. I've been on this side 8.5 years. And it's funny because I still see the world through plaintiff's lawyers' glasses a lot of the time. And so it does help when clients call me and they say, okay, I just got the call yesterday. Somebody said, okay, our employee, I just found she went missing for 2 weeks and we didn't know where she was. So we were going to fire her. And then we found out she's in the hospital. So could we fire her? I go, no, you're not going to fire somebody that's in the hospital. So
no.
that helps. I said, I can see the complaint in front of me in the
But, yeah,
court.
but the problem with something like that is, how come she's gone 2 weeks and only now you're looking for her?
No, it's a very fair question and it's definitely problematic, but terminating somebody when they're in a hospital bed is probably never a good idea.
Yeah, when you just said that I was right in my introduction, I thought you're on the part that you're smarter than me. So
That is absolutely not true.
okay. All right, we're going to jump into it. I'm glad you brought up the thing about wanting to terminate employees because that's what today's conversation is about. Um, I think for anybody who has heard me on these with Renee, you know that I've recommended her to a number of my clients. She just does outstanding work, and she's recently helped one of my clients with a difficult termination, long-term employee, and I wanted to talk about just again generally that that whole thing because this one client is not the only client that has had this. I didn't have any specific questions I wanted to run by with Renee. I just want to kind of throw some things out there because Renee, this client, and again for years I know you've had them as well. They have these employees that really are not a good fit. And then they may have been at one time, right? It may have been a phenomenal hire, but because the company has evolved or because personal things happen in people's lives, the fit is not there anymore, and they start violating policy. They kind of start doing their own thing, and they become very, very toxic for the environment. Now, sometimes employers don't do anything because they just hate conflict, which I can understand, but sometimes they don't do it because this was a friend of the family or possibly even a family member at this point, because I do have a couple clients like that. And so I know you've gotten these as well. So I guess number one, big picture, like we can start and then drill down, is um, what are your thoughts on employees who have history with an employer and maybe good history for the first 10 years or so, but then the last 5 or more years, it's really started going down. At what point do you need to say no more? Because I think, with a 90-day employee, if they're acting up, for some reason, employers think, yeah, we'll just fire them, no big deal. But once it's past that, people are really hesitant. And so what are some of the things that you run into and what are some of your thoughts on this?
So I have a lot of thoughts on it. It's very, very difficult when you have an employee. that if they start out bad and you're just like, no, I'll just put more energy and put more resources into them, and I'm sure we could turn this around, and it's just not turning around. And then all of a sudden, a year goes by and you decide to terminate them. It just, the more history you have, it gets more complicated. But the worst thing you could do, honestly, no matter how long they've worked there, but particularly if it's more than a few months, if you don't have anything documented on that employee, throughout their employment, or at least towards the end when things start to get really, really bad, then it's really difficult to terminate. And especially like if you have somebody that's worked there for 10, 20 years and you have nothing written down and then you terminate them. I mean, I've been on the phone with plaintiffs' lawyers in that situation. And I say, look, the worst thing that my client did was keep them for this many years. But then the counter argument is, well, why'd they keep them for so many years when they were such a bad employee and nothing is written down? But then it's also problematic. I mean, the client that you're talking about, Michael, it's like they did have stuff written down, but some of it was written like 7 years ago. And
Yeah.
so, like, then what? So, yeah, we have some documentation, but you just really need to be consistent in your documentation. If you have an employee that starts out amazing and then starts to fall apart on you, make sure you're documenting it, make sure you're checking in with them and seeing, is something going on in their life? Like, why this sudden change in their attitude and their, reliability and their performance? Like, what happened? And you want to make sure that you take care of people, but you don't want to just drag the relationship on, because like you said, like it does become a toxic work environment. They start to it starts to affect other people in a really bad way, and the company as a whole. There's nothing good that comes out of it.
Yeah. And so you brought up two things. We're going to kind of go back and forth because there's so
Yeah.
many tentacles to this one. The first thing is, or I want you to answer this after because I'm going to forget if I don't ask you now, but for keeping people on for a long period of time before you terminate. I'm going to give you a story, then I want to go back to that and talk about what are the dangers and how can employers try to get by that if that's the case. But a quick story is years ago, to your point, or I get these frantic calls. I've got this employee, he's horrible, he's mean to supervisors, I got to fire him today. All right, I'm done with him today. It's like, all right, let's talk about it. And this employee had been there for 12 years. Um, Constantly, arguing with supervisors, swearing at them, not really nice to other people, have attendance problems. Okay. Well, the person's there 12 years, right? I mean, why have you not, taken any action? So I asked them the same question is, okay, did something change, right? They've been there 12 years. Were they a good employee? And did they have a new manager? Was there new technology? Did their schedule change? Did something happen to flip this? And they said, no, he's been like this from day one. He's just been a pain in the neck. It's like, okay, well, let's look at documentation. And the only thing worse than no documentation is bad documentation, because he was getting reviews every year. And the review was
Right.
always a 5, right?
Right.
And so now it's like, well, and there was nothing in there about, hey, you're a great employee, just please don't swear it at your supervisor anymore. Not even that. It was just like great employee. So back to the original question now. Let's say you have somebody a long time, and let's say there is no documentation, but you decide at this point, okay, they're still screwing up. We've tried. What? How do you argue? Yeah, this has been going on forever. We just don't have documentation, but we started it because we just can't do it anymore. What? How would a plaintiff attorney poke holes in that?
I deal with this all the time. I mean, I can think of 3 examples from this week alone, literally, when I was dealing with this exact situation, 3 different clients. It's really, really hard because the problem is that in the employer's mind, from their perspective, they know that this employee is a terrible employee, and they know that the employee knows that they were a terrible employee, and they think like, what are they going to come after me for? Like, I did everything for them, and I've been, dealing with all of their stuff for all this time and just continue to pay them. Like, what do they have on me? Nothing. But the problem is that they go to the plaintiff's lawyer and they say to the plaintiff's lawyer, I was such an amazing employee and I put my entire life into this company. And then all of a sudden one day I'm like blindsided and I was terminated. Well, so the plaintiff's lawyer they know the rules, obviously they know the law. And so they start to probe, and, either they look at them and say, well, what's your nationality, or what's your religion? What's your sexuality? And they say, oh, actually, yeah, I was born in India. Has your employer ever asked you anything about being from India? Like, has he ever said anything negative about being from India? Oh yeah, no, he hates Indian food. He hates it. He makes the comment all the time about how much he hates Indian food. Oh, well, maybe he's racist, and that's why do you think that has anything to do with termination? Yeah, actually, now that I think about it, last week we were talking about Indian food, and then he fires me. It's so outlandish and so ridiculous. But I'm telling you, I can give you very real life examples of so many things just like that. An electrician that gets terminated and they say it's because I'm dyslexic, and the employer's like, when did you ever write for me? You're an electrician. Like but you just come up with something. Do you have a disability? What makes you protected? Everybody belongs to a protected class, everybody, because unless you, and I've said this, I've probably said this here, I say this all the time, unless you're, under 40, white, male, no sexuality, no religion, no nationality, no, nothing, no disability, 100% healthy. If you fit into that category, you're probably not protected. Everybody else is. So that's why it's an issue. And I have to tell you that my favorite thing from being a plaintiff's lawyer was because obviously plaintiffs lawyers do litigation, right? Defense lawyers do advice and counsel and litigation. I do both. On the plaintiff side, I just did litigation. So I get these clients coming into my office and I feel so bad for them. Wow, you loved your job and you're amazing at it. Now you can't pay your light bills. This is terrible. And I felt so bad for them. And I write the letter to the employer and say, I need records. And they say, well, no, you don't understand. He was a terrible employee. Okay, that's fine. Here's the records request. They send you the records request. I have a memory of so many times just sitting at my desk, opening up that personnel file and seeing these glowing performance reviews. And that would be my entire brief, when I would do a motion for summary judgment in opposition or whatever the case is, and or just a letter just to try to get this case resolved. And I'd say, on this date, and I would write the categories and fives down the road. Like, really, if this employee were that terrible of an employee, why are you giving them these stellar performance reviews? It doesn't jive. So if you're an employer out there listening to this and you've been like, oh, shoot, it's so hard. It is so hard as a person to look at somebody in the eye across the table from you and say, you know what? You have a lot of problems here. You're really screwing this up. It's really hard to do that. It's so much better to just, and so many employers, they just put fives down the line, exceeds expectations, and look at them and say, look, I gave you a great performance review, but really between us, you've got to change. You've got to, and if it's not written down, that conversation didn't exist. They're never going to do it. So you have to, if you're going to have these glowing performance reviews, you want to terminate somebody, you want to play the long game, start slowly writing them up, slowly documenting conversations, emails, and then put them on a performance improvement plan. I just did one yesterday because the client wants to terminate somebody and they have nothing on this guy. So we wrote him up last week. This week we're doing a performance improvement plan. You just have to play the game.
So one of the things I tell my clients is if you're not going to do reviews properly, don't do them.
Yes.
Is that a good rule of thumb? So just don't do them at all. So don't.
I mean, and nobody is a perfect employee. Nobody. There are no perfect people out there, let alone perfect employees. So even if you have an employee and they really are amazing, there's something that they could do to improve. So I would put, and you always want to put some of the good stuff, but you want to be honest. And if they're a perfect employee, then great, they're a perfect employee. Reflect that, give them their raise, do whatever you need to do. But then if something else happens that's bad, make sure to write them up on that.
Yeah. Okay. So I want to jump into severances for a sec. First of all, can you explain the difference between severances for someone under 40 or 40 and above? Because there's something specific for people 40 and above.
Yeah. So I hate this because I'm over 40. So once you're over 40, apparently you need like help and more time to review the severance, which kills me. So if that's the case, there's this law called the ADEA, the Age Discrimination Enforcement Act, I believe it stands for. And what it does is the whole purpose of giving somebody a severance, you're giving them a check in consideration of them not suing you. It's a release of claims. You can't release all claims. You can't release wage and hour, workers' comp issues, unemployment. You can release discrimination, harassment type cases, right? Types of causes of action. So you want that release. That's critical. If you have somebody under 40 and you hand them the severance agreement at the termination, they sign it right then, hand them the check, you're done, you're protected. It's great. That's like the perfect result. They're over 40, you give them a severance, even if they sign it right then and there, they have 7 days to revoke their signature, revoke the release. And if they revoke it, then if you hand them the check and then they go and revoke the release, then you basically just gave them a check of charity because they'll take the check, they'll cash it, and then they'll sue you. So you always want to wait. I always say wait 10 days, not 7. The law is 7 days. But the thought process is for anybody out there that still uses the United States mail. So if the mail gets crossed, where they send the revocation and you're sending the check, and then they get the check and they cash it, and then the revocation comes in, you have no recourse. So that's why I always say wait 10 days. And after 10 days, you should be safe to then send them the check.
Okay. So when, so I have all these things just racing through my mind right now. I always thought severance agreements would be a positive thing. But I've spoken to you. I believe you counseled me on this a little bit, and some others that have said that going and just offering somebody, let's say you have an employee who has been with you for a number of years, is now a liability, and this person is, you think, potentially going to be litigious. So you think I'm going to just head them off the pass. I'm going to sit down with them saying, look, this is not working out. We can offer you a severance agreement, right, to help you through this. Now, I've been told by some that you got to be careful with that because they can kind of use that against you, like you're trying to push them out, which again, in essence, you are. I mean, everything is a negotiation. If you don't like somebody, I just don't see why somebody can't use that as a tool to say, hey, look, let's leave on good terms. You're obviously unhappy. You're not producing the way we need you to. Why is that so bad? And at what point should a severance be thought about, initiated? And what are some of the guidelines for that?
So it is complicated.
It's a lot. I know. I'm
It's a
sorry.
lot. It is, no, don't be sorry. It is complicated because on one hand, you can say that. You can have a conversation, say, look, we both know this isn't working. This is not the right fit for you. This is not the right company. Like we know that it probably makes most sense to just like separate ways, like separate paths at this point. We're willing to offer you severance to help you with your transition to the next step. So you can say that. The problem is if they're like, no way, like I love this job, I'm not going anywhere, then they can use that as part of the evidence against you to say like it was a constructive termination, which means that's like a legal construct, which is a way to get around wrongful termination when you actually quit. So if they resign and they say, you made my job so impossible to do that it was effectively like you terminated me, even though I resigned, I was forced to resign. So you could say, yeah, and they offered me a severance, they're pushing me out, they wanted me out. So that's one risk. And it doesn't always happen that way. Sometimes employees are just like, you know what, great, let me take the money, I'll move on. I was going to quit anyway, whatever. And that's like the more normal response. That's probably what most people do. I don't ever see the when things just kind of end like calmly and happily. Like I just see when
Yeah.
it falls apart. So I'm sure most people like we never hear about these things, and like most people are just normal. I'm like, okay, I'll move on. This is, I don't want you not to like me, and I'm not happy here. You're not happy. Let's move on. But the problem is that especially in California, we have this mentality that we get fired, we have rights, we're entitled. And it's just like, if a car hits you down, even if it was kind of your fault or maybe it was your fault, you're going to call a lawyer and be like, what are my
Yeah.
rights? Because, there's money out there to be had. Same thing. I always say, like, I love what I do so much. I love what I do. But I
Yes.
do feel like employment lawyers have kind of become like the new generation of personal injury lawyers, where you have the billboards on the sides of the road. It used to be like you drive to Vegas and it's like got into an accident, need help. Now it's, were you fired? You have rights. Well, do you? Yeah, you do, because we're in California. But it's like it shouldn't be that way. And so everybody, they get fired. And I mean, I get tons and tons of calls from employees because they just know I'm an employment lawyer. They Google me or find out that, they don't know which side I'm on. And they say, I was fired. I'm like, well, why were you fired? Well, I yelled at my boss, but he deserved it. It was not a big deal. And, and it's like, well, no, they have a right to fire you for that. Do they fire you because they said, and I hate women or I hate, whatever? That's a problem. So they just go straight to a lawyer. So the problem is that if you offer them a severance, like sometimes, especially if it's like, this is a really risky risky termination, you offer them a significant severance, they get money dollar signs in their eyes. And like, well, what are they afraid of? So they go to a lawyer, and then the lawyer will be like, oh, wait, there's so much more we can do for you here. Like, don't sign that. Let's sue.
First of all, do you know how many times you've started something with, especially in California? I mean,
California,
it
it's
puts us
so
in a
hard.
whole different category. All right, so So I guess it would be, again, permissible to have that conversation, or it'd be a lot less risky, again, if you had been documenting and have at least one corrective under your belt. Because at
Mhm.
that point, you can say, look, we're still not, we're heading to the next one. We don't want to go there, right? We want you to be happy. This doesn't seem like it's a good fit. Would that be an okay time? I mean, once you have corrective under your belt, because now you're showing that pathway, you're giving them kind of an escape clause. Would that be okay, or at least, or just less risky? And should you wait until you're terminating and said, hey, we're firing you. We can give you a little bit more money out the door if you sign this for us.
It's so hard for me to answer. It's so dependent upon the situation, the type of employee that we're talking about. I mean, I just this week, or it's actually on last Friday, I dealt with a situation. It was so complicated, and there was like a hygiene issue. I don't want to get into it. It was one of the grossest things I've ever dealt with as an attorney. I'm like, this is why I'm an attorney, not a doctor, but I dealt with it. So we really wanted the client really wanted to fire this woman. I thought it was a potential disability discrimination lawsuit, which it could have been. So they're like, but they made the decision like we can't deal with this. So we did a severance, and it was very risky, but she's very young. So if she signed it, we could just give her the check. And so we had a very, very, very sense that I did it. Had a very sensitive conversation with her. And I said, look, we're offering the severance. We'll make it easy for you. Why don't you just, maybe think about it? And she signed it that day. So, but that it could have gone the other way. So it's so hard. It's so hard. I mean, I wish when clients ask me, like, they're like, well, what could happen? What could happen? And I could give you like all the potential scenarios, but like, I don't have a crystal ball. I don't know. And there's certain
Yeah,
people that just would never sue their employer. Like, I don't want to sue. I don't want to start problems. I just want to move on.
yeah.
Just give me a little bit of money to help me with the transition. I'll move on. And then other people are like, no, like, who do they think they are? And let me stick it to the company because they screwed me so bad that I'm going to take them for everything. So it just depends.
Well, things like it seems like the latter is getting more and more prevalent, right? The people, just the entitlement mentality. How dare you say I'm not the perfect employee? And then that's part of the frustration. Um, and yeah, I mean there are so many different scenarios, but again, I used to be a much more aggressive individual when I was an HR manager and with clients when I first started, but I have become a lot more uh, averse to just jumping into things, and we will take those extra couple of steps, especially over the last 5 years, definitely the 10 years. Um, is it me, or have things gotten so complicated and litigious where we it, it it's smarter to move a little bit slower than 15 years ago, 20 years ago?
Right. Well, I wasn't doing this side of it. I was
Yeah,
doing the plaintiff side 15, 20 years ago, but not this side. I
yeah,
mean, I do think it's gotten a lot worse. And I do think you have to navigate a lot more carefully. And I always say that you should really like just cross every T and dot every I before you actually do the termination.
yeah,
Because I mean, the thing that's so hard for me to explain to clients that it's disheartening, really, is that you have an employer that's trying to do everything right. They're good humans, like they're good people. They have a really, really awful employee. They're basically feeling like they're held hostage by that employee. They want
yeah,
to fire. And the reality is that that employee can say anything that they want. And then it is worth money, and even if the case goes nowhere. I mean, I have so many clients that have hired me for litigation, and I'll spend, a few $1,000s like preparing letters and writing a full response to the other side to make them understand what this case is all about. Very often it goes away. You never hear from them again, very, very often. And other times you're just still, you still have to pay for it. You still have to, defend a lawsuit that has no merit whatsoever because you have like the plaintiff's bar. And there are some really, really good plaintiffs lawyers out there that are really good about vetting cases.
yeah.
And those are the ones I like to recommend when people ask me for a good plaintiff's lawyer because they're just like they have integrity and they really like they're not just these sleazy lawyers that just want to make a dollar. But there are so many sleazy lawyers that they'll take anything. I mean, they have intake specialists in their office that are just they're not lawyers and they're not HR consultants. They're just assistants that they just get trained and they don't even you just take it. You just intake, pass it along to the lawyer and they file lawsuits or write letters. And I mean, that's what's keeping me in business is all of those cases. So I shouldn't bite the hand that feeds me. But
Yeah.
I have so much sympathy for these employers out there are really doing everything right, and they still have to deal with these lawsuits.
So, I want to end this on a conversation about managers, because it gives me a lot of hope what you just said, that you can just write a letter kind of explaining what's going on, and there are some plaintiff attorneys that say I had no idea, and I do tell my clients that a lot. It's just that when an employee goes out, they're only giving one side of the story. And the employee is never going to go to a plaintiff attorney saying, yeah, I was a real screw up. I was horrible to everybody, but I still want to sue.
Exactly.
There are some attorneys that will probably take that, but a lot of them wouldn't. Um, so the crux of this, I think, really stems from supervisors, right? Are they having the conversations up front? Are they documenting things properly? And again, doesn't have to be novels, but are they taking corrective action? Are they notifying HR or whoever's in charge of HR in a timely manner? Because so many times there has been no documentation, and we can say, well, you can recreate it, right? You don't make it up. But if you know you spoke to this person, go back and take a look at your notes. On or about this date, I had this conversation. This was the information that we discussed. Not the best, but it's certainly better than nothing at all. Um, what else or do you have any tips on just getting supervisors on board? Because that seems to be the missing link in a lot of these issues. They're just not stepping up. So
Yeah.
what can employers do?
Train their supervisors. That's exactly it. I mean, you nailed it. Like that is the key. If you spend a little bit of time and money, I mean, I love when clients find me because they're like, I want to make sure I'm doing everything right. Help me do everything right.
Yeah.
Having them pay for like an HR audit where I can just go through all of their systems, all their things, which you do also. We can, that's something that we both offer. That to me is so worth it, because then you're going to avoid a lawsuit later on where it's really expensive. Unfortunately, it's a lot easier for me to sell my services when it's litigation, because they have to have a lawyer. Like, it's not a choice. Like,
Yeah.
the prevention part is a luxury, but it's so, I can't emphasize enough how necessary that is. So training your managers and supervisors, making sure they understand what the rules are, understand the incredible significance of documentation. They understand that when things need to be documented, how, I mean, honestly, I tell people all the time, like, take your phone and, like, as you're walking, if you're so busy, which everybody is, as you're walking away from just telling an employee, you were late again. This is the third time. You really need to start being more reliable. We're counting on you. And then as you walk away, talk text into your phone and just say, I just spoke to John Smith on, May 21st at 10:37 a.m. And I reminded them that this is the third time they've been late. And then make sure to get that talk text into a email or into a document that goes into their personnel file. I mean, that like extra step of like 2 minutes of making sure that thing gets into the file is like gold. It's so worth it. And you can't emphasize that enough unless you've done proper training. But if you have if when the clients that are, I mean, I'm blown away by certain clients when they call me like, all right, I want to fire them. And so I'm like, okay, well, what do you have documented? And they're like, here, let me send it to you. I mean, this just happened like last week. It's a construction client. I was shocked. I was shocked at their level of documentation. It was incredible.
That's
And it
great.
was pages and pages and pages. I'm like, yeah, you're good. And so we drafted a termination letter that just detailed everything that was in all of their documentation, because you always want to do that. You don't want to have a generic termination letter, because then that scares off a plaintiff's lawyer. They're like, whoa, like this had nothing to do with anything that's protected about you. This has everything to do with you are a really bad employee. And so you're allowed to fire a really bad employee. That's completely legal in California. So now you have it all documented, and you just saved yourself a lot of aggravation and a lot of money.
So my last question to you is: at what point should supervisors be be written up, maybe even either demoted, right, if they can't do it, or even terminated if they're not stepping up? Because to me, this is one of the most critical things that a supervisor does. But if they're not doing it, what kind of issues have you run into on that? And again, recommendations, because it's a completely different skill set. You want to understand that, so you need to put some training dollars into them. But at what point is it, what, you're just this is just too risky. You're causing us too much liability here.
Yeah, I mean, look, if you've promoted somebody into a management role, part of their job, other than like the workload, is managing the people. So if
Yeah.
they're not managing the people properly, then you have to, it's the same. Look, the supervisor and manager, they're an employee just like the other employees in your company. They're all the same. Supervisors will sue you just as quickly as a non-exempt, lower level position. Like it doesn't matter. An employee is an employee. So if the supervisor, they have their job description, they have their tasks and their duties that they're required to perform. They're not performing those. You, owner, you, HR manager, you, whoever you are that's supervising the supervisor, you need to write them up in the same way that you're asking the supervisor to write them up. So if they're not doing their job, then these people have to, write them up and discipline them, do a performance improvement plan on them, whatever the case may be. But it's the exact same thing. So if the top person under the supervisor is or above the supervisor is the owner, it's you as the owner. It's your job to terminate them or discipline them or, keep them accountable. But it's all the same. Everybody has a function in a business. You
Yeah.
run a business because you're creating a widget, you're creating a service, whatever it is that your business is. And that's the ultimate goal. You're there to turn a profit and you're there to do right by your customers and, by society and the public. And if everyone has a role in the business and you're not there as, a charitable entity that's just, just writing checks to make sure that all these employees can take care of their families, that's not what we're doing here. So you have responsibilities. And so be accountable, be responsible. And if not, you need to hold them responsible and write them up. And it's just if everything is documented, honestly, if everybody documented everything, I'd probably be out of a job. And honestly, if nobody got sued and everyone was happy, I think I'll just find I'll
Yeah.
volunteer somewhere. Like that, I mean, that really is my goal, is to get everybody just to understand that doing a little bit of prevention can just save so much money and so many headaches. And my clients were in litigation and they're so stressed out and they're not sleeping at night and it's affecting their relationship with their spouses and their families, and that it kills me. Like I don't want anyone to have to go through that. It's really stressful.
So I kind of lied. I do have one last question that just popped up. So supervisors and training, if they are not performing at the level you need to, or they need to, and you end up terminating for that, but if you haven't put in any money to training, is there any way that that can be looked at as a wrongful term? Because there's kind of a contract, right? When you hire somebody, you're going to train them to do the job that you hire them for. I mean, there's going to be some kind of basic knowledge, of course, but as a supervisor, there's a different kind of skill set as an employee, a supervisor manager. If you're not putting time or money into helping these people develop, what risk is there for an employer? Is there some way a supervisor can come back if you do terminate, saying, well, look, you didn't keep up your end of the bargain because I was there every day. I was trying to work hard, but I just was never given that opportunity. Or is it on the supervisor to look, you're a supervisor, you're a manager now, go out and you need to learn these things on your own. There
Right.
should be some self-development.
Well, there's no lawsuit for not providing resources. But I guess that the argument is you set me up for failure. I
Mhm.
mean, the only time you have a lawsuit against your employer really is if they do something discriminating against you because of something. It's all about protected class. That is everything. So if you just have a crappy owner who just is like, just do your job. I mean, it's so stupid because you're putting so much money into everybody into making this business go. So what is the point? It's like making a product and just using the cheapest ingredients ever and not understanding why it's not selling. It's the exact same thing. Like why would you not provide the resources an employee needs to thrive? But
Yeah.
if they do that, there's no lawsuit for that. So they can't, that wouldn't be a defense, or that wouldn't be a claim by an employee. Will use because wrongful termination has to be based on a protected class. So if you have 5 supervisors and you're giving all the resources and all the love and all the support to 4 of them, and you happen to not give it to the 5th, and the 5th brings a lawsuit because they were denied all these opportunities at the other 4, and everything is equal other than the fact that this one 5th person, happens to be in a protected category, that's a discrimination lawsuit. That's legitimate. But if you just have an employer like you promote, because you think that they have the ability to do it, you should provide the proper training. But I don't think that's necessarily definitive as to how you would characterize the entire lawsuit.
That's perfect. Because this is what actually I'm putting together a webinar for next week for my clients just on this topic, right?
Oh,
Providing the resources for supervisors.
you should, but you should put
Yeah.
this is look, I know with my law firm, this is my baby. It's my 3rd child. I have two human children, and then I have one law firm child, and this is my baby. For me to if one of my employees came to me and they're like, I just need a little bit more help, and I'm like, figure it out yourself. how it like they're going to make mistakes that reflects so bad, and the business is going to end up failing. So it's just so short-sighted not
Yeah.
to put resources into your employees, because your employees are your biggest asset. They're certainly your most expensive cost of a business is employees. So why would you not put a little bit of time and attention into them? That it just doesn't even make sense.
Well, and again, just the difference between a cost and an investment, right? Because you get an ROI on training. You definitely get ROI.
Of
You do
course.
something that's just tremendous. But
Of
okay, that's it for me. Any last minute things that popped in your mind that you want to get out to everybody?
No, no,
Okay.
I think that's it. I mean, we just fed a ton of information to everybody, but
And-
just having you as a resource. I mean, Michael, you're amazing,
oh,
and
thank you.
obviously, I'm always here for everybody. And I just want just use the resources that are available to you.
Yeah. And then for those of you who want to get a hold of Renee, in the body of the email where you got this link, her entire bio is there with contact information. So reach out to her if you want to chat with me before you chat with her. I will let you know how wonderful she is. So thank you again. And we spoke. Renee and I were talking. We're going to get some other things on tap here soon because she has some great ideas for other podcasts. But Renee, thank you so very much for your time and expertise, and we'll see you on the next one.
Thank you, Michael.